Good morning, everyone. I am so delighted to be here with all of you. I have enjoyed listening and learning so much from each of you, and I'm excited to talk with you about a few issues in education law today. So, what I will be talking about today, first, the right to education and impact litigation, and second, affirmative action and two cases that are pending before the U.S. Supreme Court. And even though I'm not going to do a separate presentation about free speech, I will also mention free speech issues as we go along because they connect to some of these things in really interesting ways. And so there are changes, I think, in what's happening overall that are reflected across different areas of law. And of course, if you have questions at any time, please just raise your hand and ask. And I think if we get the microphone to you, then those who are joining us online can also hear your questions. And I'll stop at a few points and ask for additional questions as well. But before I get into this, I thought you might be wondering, where is Michigan? And so I wanted to give you a few details. So on the map of the US, Michigan there is highlighted in red. And you can see that it's the shape of a hand, right? It's the shape of a mitten. And so people who live in Michigan, when you ask them where they live, they actually hold up their hand and they say, well, I carry a map with me at all times. And then they're able to point where they live. So there's the lower peninsula of Michigan, which is the hand, and then there's the upper peninsula, which you see there up at the top. And the upper peninsula actually connects to Wisconsin, the state where Suzanne lives. So that's where we are in that part of the world. So 1837, we became a state, and the name is from a Native American word, an Ojibwe word. And since Michigan is, in fact, composed of two different peninsulas, we think that is so important that it is part of our state motto. And Michigan is, in fact, a really beautiful state with a lot of lush outdoor areas and sand dunes and forests and really pleasant area. Now, you have more people in your city than we do in our entire state. So our governor, Gretchen Whitmer, has been governor for a number of years. You'll hear her name later as I'm talking about one of the cases in Michigan. And a few things that Michigan is known for. So Detroit and the American auto industry, that's where a lot of that has really happened over the past 100 years. Oddly enough, breakfast cereal is also a very important part of Michigan history with the Kellogg company in particular. Agriculture, apples and cherries and all sorts of delicious things. And if you know Motown music at all, then that is definitely something that we are proud of in Michigan too. And my university, Michigan State University, founded in 1855. And more recently, we have also started acknowledging the ancestral traditional owners of the land. And this is something that I think is fairly commonly done in Australia when I visited and lived there, but it is just starting to happen in the US. And so we are acknowledging the Anishinaabe people. And the fact that the land the university resides on was ceded in a treaty between Native Americans and the US government. All right, now to think about the right to education. So what we'll be talking about here, let's see. I'm glancing up to see if the type is big enough. I hope you all can see. I was trying to adjust when it seemed to be smaller. So we'll talk about impact litigation. And I'm curious to learn from you all as we go throughout this. I'm curious how familiar this is, right? If this is the same sort of approach that is applied in Brazil or not. And we'll talk about two types of impact litigation: incremental or by small increments, small steps, or comprehensive, big and all at once. And then I'll talk about two recent right to education cases that illustrate these different approaches. And talking about, again, why all of this matters, both understanding the incremental holistic distinction and also thinking about a right to education in the US. So as I mentioned, impact litigation is designed, so we have two types, again, incremental and comprehensive. And it's different than what most lay people think of as a traditional lawsuit, because it's not, if someone hits my car or damages my property and I sue them because I want money for this, it's not a one-to-one lawsuit. And it's also not designed just thinking about that particular situation. So impact litigation is oftentimes more of a class action type of lawsuit, or it's thinking about a larger group. And we're thinking about changing the law in general, not necessarily just getting a particular remedy, but really changing the way that the law works. And so lawsuits are brought, impact litigation is brought with a very intentional goal. Now, this is familiar in the US context to scholars who study legislative reform, because they're used to thinking about these two types of changes in legislation. We might have a legislative change that just makes a minor change to an existing program or adds something on to something that previously exists. Or we could start with a whole new statute and a whole new framework, right? So these two very different types of approaches. And they have a lot of advantages and disadvantages. Mainly, incremental change is usually easier to achieve. It's a small change. It's a small step, right? Whereas comprehensive or holistic change is a heavier lift, is much more difficult, but it can also produce much more significant results. So here's an example of incremental impact litigation. So Brown versus Board of Education is the result of a lot of cases that lined up and made small changes in the law, one after another after another. And so Brown versus Board of Education didn't just come out of nowhere. It was the result of a long-term litigation strategy by a group of attorneys who were trying to achieve this goal of essentially overthrowing separate but equal. But they didn't go directly there. They built up to it with small changes and small changes and small changes that, like stair steps, gradually got them where they wanted to go. So Pearson versus Murray was a case in Maryland Supreme Court about a Black man being denied admission to law school. That case, again, was in state court, not federal court. And Brown versus Board was decided by the US Supreme Court. So the attorneys wanted to get into federal court, but they needed to test out their ideas a bit first. So if you are in state court, then the resulting decision is only binding in that state. So it's an easier way to test out this legal theory. So that's where it started, Pearson versus Murray. Additionally, then thinking about Missouri ex rel Gaines, Sweat versus Painter, and McLaurin versus Oklahoma. These were all small steps, and they challenged first admissions. So the idea was basically if a state provided a particular type of education, such as law school, then it needed to admit both Blacks and whites to law school. But it didn't have to admit them to the same law school. And so that was where it first started, right? So the first incremental step was to say that Blacks had rights to to have access to this same type of education. So first it started with admission, but you know what? Then when some Black students were admitted, were they treated just like the white students? Of course not. And so we had a later case where a Black student was admitted into a law school, but was not allowed to sit in the same classroom, had to sit outside the door on a desk to listen to the lectures. Same sort of thing, was not allowed to eat lunch at the same time, right? So the student was admitted, was allowed to listen to and learn from the same things, but not exactly in the same way. So that was another lawsuit that struck that down. And Suzanne, I think I might need your help waking up the laptop.
We're back on.
Oh, great. Thank you. We're good. Yes. And so eventually we have these small changes that chip away at the idea of separate but equal. And ultimately in Brown versus Board of Education, separate but equal is destroyed as a legal doctrine. So this again is an example of impact litigation in a very incremental way. So as I've been mentioning, conceptually, we're talking about small changes that build upon one another, and we're trying to achieve one small thing right now. We're looking at this particular step, but we're also keeping in mind the whole staircase that we want to ascend. Now, comprehensive impact litigation is different. So comprehensive is, I illustrated intentionally with this bridge, right? It's one thing that goes all across. And if you remember in this slide, I illustrated the incremental litigation with these various stones that are going across the pond, and you don't know exactly which way they're going to go, but each stone gets you closer and creates and closes off different opportunities. Whereas with comprehensive litigation, there's one bridge, one path, and you're really putting all your eggs in one basket. Is that a phrase you all use? Or you're at least like you're, all of your, how do I explain that? Like there's no other, you're betting on, yeah, you're throwing it all in, you're betting on one option. You're like, if this option has to work because that's the only thing that I'm going to prepare for and plan for. So this is a very different type of litigation in that it's trying to achieve this massive change all at once. And so we also have examples of this in US law. So Rose versus Kentucky is a great example, and that's a school finance scheme case where the plaintiffs really looked at this, the way that schools were financed, and they looked at what education was like in the state of Kentucky. And they basically said, we need to start over because the education that's being provided is not fulfilling the state constitutional mandate. And we can't just change it a little bit. We really need to change it a lot. We need to start with a very different foundation, start with very different assumptions, and go in a totally different direction. And that's one of, again, that was in state court, but I'm using that as an example of comprehensive impact litigation. It was successful, plaintiffs won, and the Supreme Court essentially said, here's what it means to have a constitutional right to education in the state of Kentucky. Here are all of the different types of things that students need to know and be able to do. Now, the rest of the state government, it's your job to figure out how that's going to happen exactly and to pay for that. But here's the big goal. Here's the overarching goal that we're going for. And in particular, they identified 7 different capabilities that they wanted all students to be able to have by the time they graduated. So, I think so. Comprehensive, I think of as, so incremental are these small changes, and comprehensive is kind of like jumping from the bottom of the stairs all the way up to the top all at once. Yes. Yeah. So the change is much bigger and it's much faster. But because the change is much bigger and much faster, it's also less likely to succeed. So we have, again, this comprehensive litigation at one time, and we're trying to jump this whole flight of stairs at once. Now, with the right to education in the United States, the US is rather different than most democracies around the world in that we do not have a federal constitutional right to education. There is no explicit federal right to education in the Constitution. None. A lot of Americans are surprised to hear this. My students are sometimes surprised to hear this because we talk about education as so important in so many different ways, and yet it is not written down as a federal constitutional right. So what else has been happening in this area? Well, in 1974, the US Supreme Court decided San Antonio versus Rodriguez. And this was a case that came out of Texas. And essentially, we were looking at the amount of money that some school districts had in Texas compared to other school districts. And it's important to know that in the US, a lot of money for education comes from the local area. So about 10% is from the federal government, but a lot is from the state and then the local municipal areas. So you can imagine that if we live in a very wealthy area, the schools are going to have a lot more money. If we live in a much more impoverished area, the schools are going to have a lot less money. And in Texas, and in so many other states around the US at this time, especially, the disparities were staggering. And so there was this lawsuit that was brought to challenge these disparities and say, this doesn't make sense. This isn't fair. This isn't equal. This doesn't make sense when we think about our deepest constitutional values, that we would have these really significant differences. However, the case got to the US Supreme Court, and the US Supreme Court said, well, there's not a right to education that's written down. So we don't have a fundamental federal right. And we're not sure what this argument about students in poverty means exactly. And so we're not going to look at it. We're not going to look at these cases and say that there's a problem, because what the state is trying to do, again, this is what the Supreme Court said, what the state is trying to do is to give local governments more control over education, and that includes deciding how much money they get. And the Supreme Court said that's a reasonable thing for a state to do, is to say local governments have more authority here, more power to make these decisions. And so we're going to let these disparities stand. So these plaintiffs, again, in this impact litigation, got all the way to the Supreme Court, and the Supreme Court basically said, well, we see that these significant disparities exist, but we don't see a constitutional violation. We don't think these disparities equal a violation of law, because we just don't understand the law in that way, was a lot of what the court said. So as a result, the school finance litigation and the education litigation mainly went into state courts for the next several decades. One big exception was the Plyler versus Doe case in 1982. And in Plyler versus Doe, we had some undocumented immigrants who were excluded from schools and sued, saying, well, you know, we are residents here. We are living here. Why are we not able to attend public school? And in that case, interestingly, the US Supreme Court said it's really important to let these undocumented immigrants attend schools, because if we don't, then the long-term consequences of this lead to essentially a caste system. And in the US, that's not the sort of thing that we want, is to perpetuate, to extend a caste system. So again, very strange when we compare that to San Antonio versus Rodriguez from just a few years before. But these two cases have become really important, especially in recent years. So as I mentioned, we returned to, so this litigation moved into state courts after Rodriguez. And almost every state has had school finance litigation about the right to education. So almost all of the 50 states have had this sort of litigation. Now, more recently, in the past 10 years, the advocates have returned again to federal court because they got some of what they wanted in state courts, but there were also a lot of disparities. And there were also some state courts who said essentially, oh, that's not ours to decide. That's up to the legislature. We can't do anything about that. And my state, Michigan, was one of those where the court said, oh, not our issue. Have to go to the legislature. But guess what? The legislature didn't want to deal with this and wasn't able to. And the governor's office, the executive, couldn't do anything on their own either. So we've ended up with some really significant areas of inequality across the US, particularly when state courts will not step in and ameliorate existing inequalities. So that is what has led to this new wave of cases that I'll talk about in a moment. But before we do that, I want to also explain that just like there's no federal fundamental constitutional right that's written, there's also no federal statutory right. And so Congress also has not acted in this way either. There is legislation that establishes types of educational rights, absolutely. But in terms of really establishing education as a fundamental right, no. What we have mainly is legislation that establishes anti-discrimination rights. So when students have access to education, they're not able to, similar to Plyler versus Doe, where the court said we can't deny education to one group if we give it to another. We have also seen that when it comes to race, when it comes to gender, when it comes to students with disabilities. So we have all of these anti-discrimination rights, but what we do not have is a positive, affirmative right to education of a particular quality. Yes, excellent question. All 50 states have a right to education in their constitution, but the language is slightly different from one state to another. And even when some states have similar constitutional language, state Supreme Courts also interpret it differently from one state to the next. So my state of Michigan has language that is very similar in the Constitution to the Constitution of Kentucky, where the Rose litigation came out. And that was really important. And again, took this really innovative, holistic approach to thinking about what that constitutional right to education meant in Kentucky. Whereas in Michigan, our Supreme Court justices have basically said, oh, that's not something we need to really figure out. And the right to education in Michigan is really an access right. So if you can go to some school somewhere, that'll be good enough. And so even with very similar language, different states' Supreme Courts have come to really different conclusions. And yeah, it's a great question. And so we've had almost 50 years of litigation happening in state courts and seeing how it's worked out in different states. And there have also been different waves of litigation that have focused on different things. So at first, the litigation really focused on inputs. So how much money did this school district have compared to that one? And then it evolved to thinking about, well, what sort of opportunities are students able to have? And money is a part of that. The finances are a part of that, but it's not just looking at the balance sheets and saying, how much money does this one have and how much does that one have? So thinking more about what they do with it. And then another area of litigation has also built on that and said, oh, thank you so much, Suzanne, has also built on that and said, well, let's really think about what the students know and can do at the end of their educational experience. And we recognize that some students will have limitations, particularly students with disabilities, but it's not just about putting money in, it's about using it wisely and using it to create opportunities.
They can legislate about teachers for theater or organizing school breakout,
Oh, interesting. Thank you. Thank you. Okay. So I want to answer the question. So this is wonderful context from Professor Nina for me to be able to answer your question about some similar things in the US. So in the US, our basic education, so primary and secondary education, about 90%, 85 or 90% of students in the US attend public schools. So the vast majority of children in the US attend public schools. Some private and a smaller number are homeschooled by parents. And that's changed a bit with COVID. And so that's still a bit in flux. And so how the finance, just a minute. Yeah. So how the finance works is that for an average school district, about 10% of their money comes from the federal government. And then, so we have 90% remaining. About half of that, so 45% comes from the state and 45% from the local municipalities. And states also have what they call an equalization fund, which sounds similar to this federal fund, because for a very rich municipality that is able to get a lot from taxing their residents, they will have a lot more to spend on education than a very poor, very small municipality per student. And so an equalization fund can close some of that gap. Yeah, so homeschooling laws are set at the state level, and there is a lot of difference from one state to another. Michigan has laws that make it very easy to homeschool children. And so sometimes if people want to homeschool their children, they will come to Michigan because they don't have to do much reporting or administration around that. So the parents have a lot of flexibility. But other states are more demanding in terms of the reporting that they require for parents who are homeschooling their children. Now, I'm not aware of states where parents receive money for homeschooling their children directly, but there's an increasing number of changes to tax law and also vouchers that make it easier for some of the money that would normally follow the student to a public school to go to a private school, or they make it easier for parents to not be taxed on some of the money that they spend on children's tuition. And so some of that might be able to apply to homeschool, but that's, again, particularly because of the very small number of students who are homeschooled. I don't think we're moving in that direction yet, but I wouldn't be surprised. Yeah. So the question was about how the government controls the learning of the students in homeschools. And in some situations, there is basically no control or oversight. And then in other situations, they want students to take certain tests that the students in public school are normally taking.
Thank you very much.
Thanks. Okay. So there's this question that many people ask in the US of why do we really need a federal right to education? So okay, should I click on the blue one? Nope, the other one. That's why I asked. Thank you. Is this about restarting or something? Okay. Okay, there we go. All good, all good. So in the US, a lot of people say, well, you have a right to education in each of the 50 states. Why do you need a federal right to education? And I think that's an important question. It's good to be thinking about that. And what I have seen and what I've documented in some of my scholarship is that we need a federal right to education because we do not have all of our children in every state receiving adequate education. We do not have a uniform floor, right? We have some students who are receiving amazing education, a lot of students who are receiving amazing education, but there are also gaps. And basically, in some states, no one is accountable for the gaps, and the children themselves cannot do anything about it. And when I talk about the case that was recently in Michigan, you'll start to understand a bit more of what I mean by this. So establishing this floor is very important. And we need it to be a floor that says there is an education of basic minimum quality that every child in the United States should have access to. That is a quality of education issue, and it's also an equality issue, because when children are denied access to educational opportunities, this doesn't happen in the same way to all populations. This impacts racial minority populations and children and families in poverty in a much, much greater way. And so we have this inequality that exists, and it really is borne most heavily by some of the most vulnerable members of our society, who are also a lot of times the least able to advocate for themselves and to advocate within the system. So this is the Michigan case that I've been referring to. Gary B. is the name of one of the students, and Whitmer is the name of the governor. Now, it started as Gary B. versus Snyder, and then it changed to Whitmer because the case went on for a long time and we got a new governor while the case was midway. So this case really started with state constitutional language when it began. And we tried to pursue it in the state courts and really didn't get anywhere. And we had state constitutional language, and we also had state legislation that said every child must be able to read by third grade. Every child in the state must be able to read, which is a really significant quality provision, right? So when I'm talking about a floor of minimum quality, that's an example. Now, a lot of children are reading in kindergarten. Most children should be reading in kindergarten or first grade. So third grade, that's not a high standard, right? It's a low standard, but it's a uniform standard that can exist. So first, this case was brought in state court and it didn't go anywhere. And then the attorneys who were thinking about this litigation, thinking about the change they wanted to produce, they said, well, let's try going back to federal court. And instead of thinking about state constitutional law, let's try to think about federal constitutional law. Let's go back and think about that Rodriguez case. Let's go back and think about that Plyler v. Doe case and see if there's anything we can do. And this has become known as the right to literacy case, because what the plaintiffs claimed was that children in a number of schools in one of our larger, poorer school districts were denied an opportunity to learn how to read and to learn how to read at grade level. And so in this case, the plaintiffs talked about schools where they did not have air conditioning in the summer and the windows did not open. So it was so hot that some children got physically sick in the winter, and our winters get cold, let me tell you. In the winter, not all buildings had heat. And so children were wearing their winter coats and boots in class. Additionally, there were rats and other sorts of vermin in the buildings. The books were over 30 years old, and they didn't have enough books for the kids in the classes. And they also didn't have enough teachers. There was one 8th grade class where basically they didn't have a teacher the whole year. And so one of the 8th grade kids taught the class, essentially. So it was just a disaster. And so, again, remember what we talked about. In Michigan, we have a state constitutional right to education, and yet our state courts have said, oh, that basically means you have an access right. And it seems like the access rights have been satisfied. So here in the Gary B case, the plaintiffs are looking at this situation and the attorneys are looking at this situation and asking, how can we make changes in the law that have a broader impact? Because what's happening in these schools is not okay. So as I've mentioned, in the US Constitution, no explicit language about education or literacy. And here in this case, they focused on literacy. They didn't go big and say there's a federal right to education. They went small and said there's a fundamental right to be literate and to have an opportunity to become literate, which means obviously at a very basic level being able to read, but then a 12th grader should be able to read at a different level than a 5th grader or a kindergartner, right? So it's not just sort of this basic, can you read or not, but also what's the grade level? And in these school districts, almost all students were failing the proficiency tests in terms of reading at grade level. It was absolutely shocking. And the reasoning here, the reason they focused on literacy is they said, if you're not literate, if you're not functionally literate, how can you meaningfully exercise your right to vote? How can you meaningfully exercise your right to free speech? How can you be an active citizen and member of our democracy if you don't have this really small but incredibly important ability to be functionally literate? And so the plaintiffs here said, no, it's not written down anywhere, but if all of these other constitutional rights mean anything, then we have to have an ability to read first. And so it should be an implied fundamental federal right. Now, I've talked a bit about the facts of the case and the horrific conditions in many of these schools. So in federal district court, so the federal trial court, the first thing that happened, as I'm sure is very common as well, there was a motion to dismiss to say, essentially, as I tell my education students, motion to dismiss means even if everything you say is true, plaintiffs, it still doesn't violate the law. So we had a motion to dismiss. What was very unusual is that this case almost immediately got incredible national attention. And there were amicus briefs, so friend of the court briefs, that lawyers and scholars from all across the country were filing in this case on this little motion to dismiss at the trial court level. And I was one of those scholars who filed an amicus brief in this case. And the court had never had these friend of the court briefs at this early stage, at this level of the judiciary. So they didn't even know what the procedural rule was. We just all looked at the appellate court's procedural rule to figure it out. And I mentioned that to underscore how unusual it was to have all of these amicus briefs. So there were two issues here. Number one, is there a right to education under federal law? And number two, could the state of Michigan be liable for violating that right to education? Because we've talked a bit about who controls education, and in the US, it's very much at the local level for making a lot of curriculum decisions, for hiring teachers, for doing all of these sort of things. So there is a lot of local control and there is some state control. But in this situation with this particular school district, the state had been much more involved for many, many years and doing a lot of things and making a lot of decisions that the local municipal school district normally would have made. So those were the two legal issues. Again, long before the court would have gotten to any factual issues, those were the two legal issues. And the district court judge said, if there is essentially, there's no right to education. I don't see that. That argument doesn't make sense to me. There's not a fundamental implied right to education. But if there were, the state of Michigan would be a proper defendant in this case, which was very, very unusual. So the plaintiffs lost at the trial court, the federal district court, and then they went to the federal appeals court. And our federal appeals court, our federal appeals judges hear cases in a 3-judge panel. So this decision was 2-1 in favor of a right to education. So this was a huge, monumental, groundbreaking decision. And then all of the judges on that court decided that they didn't like that, essentially, and they were all going to rehear that case together. So that changed the dynamics significantly. So we have this victory for the plaintiffs, and then a short time later, the whole federal appeals court says, let's think a little bit more about this. Now, during that time, the plaintiffs and the governor's office settled the case, and they were able to designate about $2 million for literacy instruction in that one school district, which it's a big school district. That money does not go that far. And the governor also agreed to introduce and support legislation that would support this direction and support literacy instruction. But mainly, why this settled, in my personal opinion, my guess here, is that the plaintiffs did not want to have adverse precedent. The plaintiffs did not want to lose at the federal appeals court. They had already won at the federal appeals court, which was tremendous. They would probably lose on appeal for the en banc court, and they would probably lose if this ever went to the Supreme Court. And in a common law system, of course, when you have adverse precedent, that is really problematic because that is there for a long time. And so in this case, it was like riding a roller coaster, you know, being part of this case and advocating in this case. And one of the big outcomes of this, I think, is that this got so much publicity, and this really helped to inform and shape the public debate. And so when we're thinking about impact litigation, so this was incremental impact litigation, and ultimately it didn't win. So it didn't get up that first step. So basically, we're back where we started. But it also made a whole lot more people aware of these issues. And that's another way in which impact litigation can function, is it really can draw attention to these issues. And especially by framing this as a right to literacy, the plaintiffs' attorneys did a really fantastic job in making this case not only something that was happening in courts, but something that was relevant to a lot of people's lives and experiences. And even if it wasn't their own experience, for a parent to be able to, you know, a parent like me to say, oh, my kid has a really great public school education. And these kids have what sort of opportunities? What sort of circumstances are we expecting them to learn under? You've got to be kidding me. And so influencing and shaping the public debate is also a large part of this. So I want to pause for questions here. I have another case that I'll talk about, not in as much detail, but just to give you an example of another right to education case and comprehensive litigation. But I'm wondering what your questions are, what your thoughts are, how this is similar to or different from your experiences and the law here in Brazil. Okay, so a lot of similarities.
We have another court
called Superior Tribunal de Justiça, like Superior Court of Justice, that deals with some conflicts, jurisprudential conflicts, but not related to constitutional law. Generally, constitutional law are related to our Supreme Court. So their decisions generally are binding, especially when you feel a case, a case for discussing the constitutionality of a law. So that the dynamics is a little bit different. I don't know if it's clear. And it's hard to explain, actually. And that's it. Será que eu complemente de alguma outra forma? Perdão. It's very hard to think about something similar to the incremental impact. I cannot think about it. Mas talvez I think it's more related to the comprehensive way of litigating. This is incremental.
On the comprehensive impact, but not incremental.
Yes,
Due to the system.
Yes, and that's fascinating to me because in the US, the incremental is the dominant model, again, because of the precedent and the way that precedent functions. And so here, understanding that it's really the comprehensive and that relates a lot to the Roman model is really interesting.
The Supreme Court stated that this school is also basic education.
Oh,
And
yeah. Yes.
change ever.
Yes.
And after was amended to include in school in basic education.
Mm-hmm.
They are not obliged to, but the decision was so important.
Yeah.
It's like to discover a new fundamental right that
Mhm.
have to be a constitutional right.
Yeah.
Implement.
Yeah. I think there was a comment up here, and then we'll hear from a few others. Yeah.
Just a quick doubt. I was wondering about the difference between class action and impact litigation,
Mhm.
because class action, there's this intent to have the collective effects.
Yeah.
And I was wondering if in the impact litigation, people, when the plaintiff starts, they are aware that all this impact, this collective impact are going to come if there's this intent, or if they are just like fighting for a very specific right. And then there's all this other people who engage in this litigation, then it becomes very important to a larger group.
That's a great question. So there is some overlap between class action and impact litigation, but there also are some differences. So if I think about a typical class action litigation in the US, it probably has something to do with consumers or like some sort of health risk or something like that, right? So some of the class action litigation related to medical devices not working properly. So in that situation, the goal is really to hold the company responsible for its error that caused a lot of harm, and for all of the individuals to receive some monetary reimbursement or something to account for their harm. So when I think about a class action lawsuit in the US, that's traditionally what I think about. When I think about impact litigation, it also can involve a large group of people, but our goal is not to achieve monetary damages, but really to change the underlying law. And so again, we can still be talking about the impact on a very large group of people, but in typical class action litigation, they're not trying to change the law. They're not trying to change the meaning of tort law. They just want to say, okay, we have this, and company, you violated it, and you need to pay out a lot of money. So that's a distinction. But you're absolutely right that both of these are very intentional about trying to achieve change for a large group of people. So, and it's a very good question. So there are a couple of more things I want to say here. One is that impact litigation in the US often involves groups of people. So in the US, we're often thinking about a racial or ethnic group. And so it's going to be this group of people that's impacted, or it might be a group based on some other sort of characteristic. But we're thinking about a lot of times anti-discrimination rights as opposed, or we're thinking a lot about anti-discrimination. And there's a big difference here, for example, when we think about free speech, because free speech cases are usually about one person, and I said something and then I got in trouble for it, or I was denied an opportunity for it. And that case might end up changing the law. Some of the most famous ones do, but it's not thinking it's built around one plaintiff and one set of facts. and not this generalizable set of facts that applies to a large group of people. And those cases also have not been brought, they really have come out of the facts. They haven't been part of this long-term litigation strategy, like the strategy that led up to Brown. So they're even within constitutional law, there's some really important cases that I would say are impact litigation and some that are not.
Thank you very much.
Was there another question up there? Okay. Sure. Shall we have a break? Shall we go for a few more minutes? What do you think? Break? Let's break. Hello. So hello again. We are returned with some of that amazing Brazilian coffee. Oh, I will miss that, I tell you. So what I would like to do with the time that we have is I will talk a little more about this idea of comprehensive and incremental litigation, and I'll give you an example of comprehensive, and I'll talk about some of the reasons why this matters in the US. And then I would like to turn to affirmative action. And my understanding is that affirmative action is a very, very prominent topic in Brazil as well. And so I'm looking forward to learning from you all about your experiences and the changing policies and changing laws, which some of which I understand have changed very recently. So to begin with, the comprehensive litigation, Cook versus Raimondo is another case. So we spent a lot of time talking about the Gary B. versus Whitmer case out of Michigan, and Cook versus Raimondo is out of Rhode Island, so different state. And it's so interesting to me because one of our education law colleagues, Michael Rebell, wrote a book and said, here's what I think a right to education should be. And he really focused on education preparing citizens. And then this litigation really puts his theory into action. And so it's a wonderful example to see this connection between research, informing practice, and really shaping the world. And so what Professor Rebell is arguing is that education should create civic knowledge and civic skills, experiences, values, and also racial and ethnic integration. And so he's looking at the state of the law in Rhode Island and essentially says, okay, we need to start over again. And we need to start by looking at the purpose of education. And that purpose needs to be focused on these civic outcomes, these outcomes that relate to being a citizen and to being an active part of democracy. And that should be the core purpose of public schools, and that should be the foundation for how we design everything else. Now, this case did not fare so well. It was dismissed at the trial court. And then it was also the appeals court also upheld that. And interestingly, this case also settled. So just like the previous case we were talking about, which settled, this one settled as well. And the Rhode Island Commissioner of Education agreed to establish a civics task force. So something that's so interesting to me in these cases is that sometimes the plaintiffs and the defendant, who is the state, sometimes their interests are very much aligned. So when in Michigan, when our current governor, Gretchen Whitmer, was campaigning, she talked about the Gary B. case and she supported the plaintiffs. And then she became elected to the position of governor, which meant that her name was the defendant. So she was defending the state of Michigan. But her interests were really aligned with the plaintiffs. And so in this case, we also see some alignment between the two parties, which is not usually how litigation works, right? And so we see the outcome being the establishment of this civics task force and really the elevation of these ideas. So Cook versus Raimondo, again, really seeking a larger, much more substantial change. And even though it didn't get the legal outcome it wanted, it still was able to draw public attention to these issues. So a few thoughts on why this matters. So a lot of times when we think about education reform, at least in the US, we often focus on statutes and regulations. We don't focus on courts as a way to achieve this systemic reform and a way to achieve systemic education reform. But that's absolutely what it is. Because again, even if the plaintiffs don't win in the end, they still change the conversation. And that can be very impactful as well. Additionally, this litigation often involves expert witnesses, researchers, and so it's a way of connecting research to the law and a way of using the expertise of research to shape cases. Again, in Michael Rebel's situation, he worked out the theory in his articles, in his books, and then he put it into practice in court. But oftentimes, we have lawyers who are drawing on social science evidence and also, again, making that connection between research and practice. So something else here, litigation goals can be short-term and long-term. And that's another thing to be thinking about with this type of litigation. Because normally we just think of a short-term goal for litigation. I want to win this case. But impact litigation has a much longer view. Additionally, as I mentioned, these type of cases really benefit from and need a strong partnership between researchers and lawyers, between practitioners and scholars. And so one of the things I love doing is pointing this out to my students when I have both education researchers and law students in my classes. And I look at them and I say, if you want to make a difference, you will need to work with each other. So, I want you in this class together so you can start learning what the other, what the other people know and thinking together about these issues, because one of you alone is as unlikely to be able to make this change, but working together, you're more likely to be able to. And then finally, someone was asking me about this. I received a couple of questions about this, which are good questions. So education is, as we all know, an international human right, but that's not how we talk about it in the US. We don't talk about human rights issues happening within the US. In the US, the conversation assumes that human rights issues are war crimes, are things that happen other places, right? So in the US, we don't have this conversation around education as a human right. So we need additional attention. We need this additional focus. And we do think about education as a civic and political right. So we definitely do that. And we think about the connections between education and anti-discrimination. And the inequality that we have, of course, oftentimes is a direct outgrowth of systemic racism. And fundamentally, my view, and perhaps many of you share it, is the idea that every child deserves a solid basic education. And in the US, I think of courts as the backstop, right? They're the backup. I would like to have legislation. I would like to have the legislators supporting high quality education, but that doesn't always happen. So I think that legislation is the first place that we need to be thinking about education reform. But we also need courts because the legislators are not always holding up what I would say is a constitutional right to education. So those are a few thoughts that bring our first topic to a close. And I think I might, I want us to be able to get into affirmative action a bit. So are there any burning questions at this point? Okay. Mhm. We have a lot of answers, and they're often very different. And so I think in that way, it's probably quite similar. And I say that in a joking manner, but I also mean it in a very serious way, because we have had litigation in all 50 states around the quality of education and the amount of financing it takes to achieve a certain level of quality. And those states have decided very different things. So I imagine it's, yeah, I imagine it's similar in that way. Yeah, bringing social science evidence into courts can be very important, especially when the cases rely on statements about society or statements about experiences, and we're saying this is true, or this leads to that particular type of outcome. We want to do more than just say that, right? And so drawing on research can be a very powerful way to make that case. And also being able to frame that research, contextualize it, and translate it in a way so that it's easily understandable. All right, so let's talk about affirmative action a bit. So we have two really big cases in the US right now. I'm curious, who's even a little bit familiar with these? Who's heard of these? Who knows that they're going on a bit? Okay, so we have a little familiarity, but not a whole lot, which is fine. I just wanted, if you all happen to know about these for some reason, I wouldn't want to tell you things you already knew. Okay. So here, I'll spend a few minutes talking about a brief history of affirmative action in higher education, talk about our pending cases, and then potential directions where this might go. So in the US, affirmative action started as a policy in 1965. And President Johnson issued an executive order, and it required that federal government contractors, so people who were doing business with the federal government, that they take affirmative action, so affirmative positive steps to make sure that their employees were not being discriminated against based on race, color, national origin, et cetera. And oftentimes this meant hiring people who were not already represented in the workforce. So this was a way to diversify the workforce by requiring that federal contractors have more diverse employees. So we have 5 cases that have been in the US Supreme Court about affirmative action in higher education. And I'll give you the highlights here. So in 1978, we had the Bakke case. And in that case, a medical school decided that it wanted to have a more diverse enrollment, and both to combat past discrimination, and so people were so it was producing doctors that looked more like the communities and the country that they were serving. So University of California said, we have 100 positions that we are admitting students to. We will hold 16 of those to make sure that we have at least 16 racial minority students. And this went up to the US Supreme Court, and the court struck down this practice. And what it said was that this use of race was too much, that race could be considered in admissions decisions, but that essentially the court did not want students getting into med school because of their race alone, was how the Supreme Court phrased it. Though, of course, in order to get into any medical school, someone would have to be very well qualified. But it was that extreme focus on race that the Supreme Court said, no, race cannot be that important in your admission decisions. So we had many, many cases after that. And what a lot of universities started doing was thinking about holistic admissions. And I'll come back to the case law slide in a moment, but what's holistic admissions? Well, it means we think about everything about a student, not just what are their grades and what are their test scores, but what opportunities did they have? Did they have a lot of opportunities and didn't take advantage of many of them? Or did they have very limited opportunities and considering that they did amazing? Also, what are their different life experiences? How can they make the school itself more diverse? Because here we started focusing on the idea of a racially diverse student body being a goal that a university could have, being a compelling governmental interest. So a good enough reason for a university to think about the use of race in admissions decisions. And by the way, I'll also say with holistic admissions, we have a practice in the US that we refer to as legacy admissions. And that means that if I am a legacy candidate, I have a family member who already went to that school. And lots of universities preference people who have a connection like that. So that's been part of admissions for a long, long, long time. So it's this holistic admissions model that really dominated a lot of university admissions. Okay, so that is what really came to be prominent after Bakke. Now, in the Gratz and Grutter cases, so that's the bottom left and top right, that's a pair of cases that the Supreme Court decided in 2003. These were both from the University of Michigan, which is very, as you may imagine, very close to where I live and another university in the same state. So we had an undergraduate admissions practice where they received 13,000 applications and they were going to admit 4,000 students. Can you imagine how much work it would be to think about that holistic admissions process for 13,000 students and make 13,000 decisions like that? It's a massive amount of work. So what the University of Michigan and a lot of other really large institutions did was they would assign points to different things, like your scores were in this percentile, you get that many points. You did sports, you get this many points. You did volunteer activities, you get this many points. And they also said, you're a member of a racial or ethnic minority group, you get this many points. So that's how the undergraduate admissions system went. And the Supreme Court struck that down. They said, we do not want this to be considered a plus factor. We do not want individuals to get points that are based on their race or ethnicity alone. So the Supreme Court struck that down, but it also upheld this holistic admissions process that the University of Michigan Law School had used, where they didn't get as many applications. They were able to look at every single application and make a holistic admissions decision on every one. And so in Grutter, they said, yes, that makes sense. We're comfortable with that. And if you remember the equal protection diagram that Professor Suzanne showed yesterday, it was that triangle about the levels of scrutiny. And how I sometimes think of that is that the top level, strict scrutiny, is where the court wants us to be the most careful. So if we are making a decision that involves the use of race, we need to have a compelling governmental interest. So a really, really good governmental interest. And the use of race needs to be narrowly tailored. So it needs to be really specific and lined up very closely with that compelling governmental interest. So in the Grutter case, it was very important that the court said having a diverse student body is a compelling governmental interest. We agree with that. That's a very important thing. And for now, thinking about race as part of the admissions decision is okay. But they also said, we don't think that'll be needed forever, right? Things are changing in our society. Things are getting better. So, well, maybe in 25 years, we won't need to do this anymore. So they were very cautious about the use of race, but they did permit it. Now, I'll mention quickly that then there were two other cases, the Fisher case, which came up to the Supreme Court twice, once in 2013 and once in 2016. And in that case, affirmative action was still upheld in basically the same way it worked in the University of Michigan Law School case. And Abigail Fisher, who was the named plaintiff, eventually became part of the group that is now challenging the Harvard and University of North Carolina cases. So she started working with an attorney named Edward Blum, who is thinking about these challenges to affirmative action in the same way. He's thinking about them as incremental impact litigation, right? So the same way that Thurgood Marshall and Charles Hamilton Houston were trying to strike down separate but equal with little incremental steps, that's essentially what's happening here in these affirmative action cases. We now have attorneys on the other side of things who are trying to strike down affirmative action and being very strategic, very thoughtful and incremental about it. So in the University of North Carolina case, first, the legal issue is a federal constitutional issue because the University of North Carolina is a public university. So it's the Equal Protection Clause from the 14th Amendment. And as we just talked about, that's why the legal standard is the highest standard for equal protection. It's strict scrutiny. So the court is again considering whether diversity can be a compelling governmental interest. And the University of, sorry, I'm not sure exactly what's going on here. And so the University of North Carolina has said, we want to have a diverse population for a lot of reasons. And in fact, if we stopped thinking about race, then we would have a much less diverse student body than we already do, in part because the state public schools, the primary and secondary schools, have a lot of inequalities. And so people from racially and ethnically minoritized groups do not have access to the same sorts of opportunities. So if we stop thinking about race and how that influences people's opportunities, then we're going to end up with a student population that looks very different. So we have another case, and these are really combined, so they're being argued at the same time. And this one is against Harvard. So this is the first affirmative action case involving a private university, because our affirmative action cases that we talked about, they're all involving public universities. They're all focused on the Equal Protection Clause in the 14th Amendment. But this one is different. And so it's focused on Title VI of the Civil Rights Act. So the federal government does provide some money to Harvard, of course, in a number of different ways, just like they do to most private universities. And so the legal hook here is to say Title VI of this statute says you cannot discriminate based on race. And the plaintiffs say what you're doing at Harvard by using this holistic admissions policy, you are discriminating based on race, and you cannot do that. Now, the big question here, the $1 million question, as we say, is really, what is racial discrimination? Does it mean being colorblind or color conscious? So if I'm trying to create a racially diverse student body, can I be thoughtful? Can I be mindful of the race and ethnicity of students, of applicants, as I'm doing that? Or is it constitutionally wrong to think about the race and ethnicity of students at all? Do I have to totally ignore that and the impact that it might have had on students' lives? So that's the big question here. And that's why these attorneys have brought the two cases together, one against a private university and one against a public university. Another thing that's very unusual about the Harvard case is that in all these other cases, white students have been the plaintiffs, because white students have said, someone else is getting a seat that I should have had. But that's not what's going on here. So the focus here is that the plaintiffs are saying that some Asian American students are being denied seats that less qualified, and I'm using the air quotes here, that supposedly less qualified students are getting because of affirmative action. And that's also really unusual in the American context, because our affirmative action cases are usually about the Black and white dynamic. So where are these cases? Well, the court agreed to hear the case January of 22. It was argued this past October. And because the US Supreme Court decides all cases for a given term, they decide all cases by the end of June. And the big decisions usually come out at the very end. I think most of us are expecting that this will come out in June of this year. So, potential directions. So what might happen? So we talked about the Equal Protection Clause, that it might be that the court says it's no longer a compelling governmental interest to have racially diverse student body. I was trying to think about the narrow tailoring argument and whether there are other policies, but honestly, it's hard to think about how they could still be conscious of race, but use it less than holistic admissions. So I don't think this case is about narrow tailoring. I really think it's about this equal protection law issue and whether diversity is a compelling governmental interest. And then there's also this question of what exactly does racial discrimination mean in a legal sense? So, as I mentioned earlier, there are a couple of ways of thinking about racial discrimination. And the two ways that dominate American law and really have been part of our American legal discourse since Brown versus Board of Education are anti-classification and anti-subordination. So with anti-classification, we say we should not be thinking about race. It is constitutionally wrong and harmful to be mindful of someone's race as we're making decisions. So, for example, in Brown versus Board of Education, the anti-classification view would say, thinking about the bad thing that happened was that we looked at students as members of racial groups. Okay, so that's been a dominant view in a lot of US law. So what's the other view? The other view is anti-classification, or excuse me, anti-subordination. So here, the idea is not, it doesn't matter so much that we think about people's race. It matters what happens after that. If we're thinking about people's race so that we can separate them and subordinate one group, under the anti-subordination view, that's the problem. It's not being aware of people's race. It's trying to keep one group down while giving the other group opportunities. And so with anti-subordination and this understanding of equality, that's where this term that we use, color conscious, comes from. So it's the idea of being aware of race and ethnicity and being aware of the impact of that. And really thinking about, okay, what's happening, across our society, what's happening systemically. So some implications short term. There's a lot of concern about how these cases will be decided because of the current composition of our Supreme Court, which is really, I would say, pretty hostile to affirmative action, pretty hostile to racial equality arguments. And so at least racial equality arguments as I think of them. And so a lot of folks are saying, if affirmative action is struck down, if we're no longer able to use holistic admissions, then we will see our student enrollment at universities become much less diverse. And this will perpetuate systemic racism, perpetuate existing inequalities. It will make things a lot worse. Additionally, there are questions like, what would it look like in admissions if we really did not consider anyone's race? Because oftentimes on students' applications, they will say, I was a member of this student organization, and it's a group for African-American students, or it's a group for Latino students. And so if they say, I was a member, or I was the president of this organization, that suggests their racial or ethnic identity. Names, first names and last names, often also suggest racial or ethnic identity. And students, as they're writing their essays, their application essays, they are often asked to reflect on some of the most significant and meaningful experiences that they've had in their lives. And for a lot of racial and ethnic minority students, those are experiences involving discrimination and how that changed the way they thought or how they responded to that, or maybe how that shaped their path to university. So what does it look like if all of a sudden we are not supposed to consider any of that sort of context? So that is really difficult to try and figure out at a pragmatic level. So a few more thoughts here. And so I want to tell you this slide, I did not make this one. This is a stock slide that PowerPoint has. So, when you can click next slide, I clicked something and it was something about the workplace. And I thought, oh my gosh, that's really interesting. Their standard slide that exists within PowerPoint is this really racially and ethnically diverse group of individuals, right? And I thought it was so ironic that I was preparing this material and thinking really about the longer term impacts of less diverse universities. One big longer term impact is that our workplaces in the US may not look as diverse as this anymore. So again, thinking about economic standing and mobility, participation in civic life and democracy, just inequalities exacerbated across these different levels. And then I'm also thinking a lot these days about political polarization and the ways in which groups, whether they're political, racial, ethnic, religious, the ways in which groups are more and more siloed and less interactive, right? And we become more and more isolated and more polarized. So are there any silver linings here? There's one I've been able to think of, which is not a lot here. But I do think it's significant because it's interesting to me that the diversity rationale is, as the courts have talked about it, it's not just about equality for students who have been marginalized and excluded. It's also about enriching the experience of white students. And in a way, I understand that very well because I am a white woman and I benefit immensely from learning from perspectives of people who have different life experiences and histories than I do, and who see the world and experience the world in different ways. And yet, there's been increasing criticism about this idea of, well, why should this benefit have to come at a cost to those who are already bearing so much of the burden? And so this reminds me of Derek Bell's idea of interest convergence, which is that racial and ethnic progress really only happens when the interests of the minority align with the interests of the majority, or the white interests, most typically. And so it would be interesting to have the diversity rationale off the table, because it would eliminate that idea that the benefits of diversity for white people have to be created by minoritized individuals who are already burdened heavily. But honestly, I think that's so far outweighed by all of the other challenges and disadvantages that I see, that even that conceptual shift, I think, is not something that's particularly helpful. So I am sorry to end on such a terribly depressing note, but I decided that I wanted to present more on affirmative action today, especially after learning from a number of you that this was such a prominent issue in Brazil. And so I was thinking in particular that I was hoping to plant some seeds for conversations during lunch and later this afternoon so that you could have this American context and perspective. And I would be so grateful to learn from you much more about what's happening here in Brazil. Yeah, that's a good question. I don't know why either. And, certainly Harvard has not been the most diverse institution. And I'm remembering Sonia Sotomayor did write about her experience at Princeton and Yale in her autobiography. And so thinking about, she wrote just about how many challenges there were and how incredibly difficult it was. So I'm sure it was not easy for her. Yeah. 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 Yeah.